Thank you very much. Please be seated. This is the time set for oral argument in HAWKINS and Mascaro, along with their minor children, versus SECURA Insurance, our cause number 1CA-CV150267. Let's begin with introductions of counsel.
Well, good morning, Your Honor. Your Honors, Joel DeChancio and Christopher Robbins here on behalf of SECURA.
Good morning, Your Honors. Dave Wattell on behalf of Patricia Mascaro and her children.
Thank you very much. Thank you for joining us today. Let me go through a few preliminaries. Each side has 20 minutes. If the appellant would like to reserve time for rebuttal or reply, when you go to the podium, let us know how much time you'd like to reserve, and we'll try not to poach on it, so you'll actually end up with it. We are recording the proceedings today, both audio and video, and so when you go to the lectern, would you please restate your name for the benefit of individuals who may be listening to the oral argument. Let me advise counsel and the parties that we have reviewed carefully the briefs in this matter, reviewed pertinent portions of the record. We're quite familiar with the issues you've raised, the arguments, and the basic facts in this matter, and you might like to take that into consideration, our preparation into consideration in your remarks today. So with that, let's go ahead and begin with the appellant.
Thank you, Your Honor. Good morning. Again, Joel DeChancio, along with my partner Christopher Robbins, on behalf of SECURA Insurance, would like to reserve 3 to 4 minutes for rebuttal. Your Honors, may it please the Court, opposing counsel, we're here on behalf of Appellant SECURA Insurance today to request that you vacate that part of the judgment pertaining to the uninsured motorist claim, judgment against SECURA, and remand to the trial court to enter judgment in favor of SECURA on the grounds that the plaintiff in the underlying case failed to satisfy the requirements of the corroboration provision of ARS 225901 subsection M. In the alternative, we ask that you remand the case for a new trial based on the grounds that SECURA was deprived of a fair trial because of opposing counsel's violation of orders in limine. I'd really like to focus on the corroboration issue. I think that's the most important and the issue that needs the most attention. We would break down the corroboration issue really in kind of three components. The first issue is Ms. Mascaro in this case never advanced a representation that did not involve physical contact. The corroboration provision in ARS 225901 requires that an insured provide a representation that the unidentified uninsured motorist caused the accident. I'll refer to that as a causation representation. Ms. Mascaro asserted in this case no causation representation that involved a miss and run, which is what the statute essentially requires. Her representation can be kind of stated in four subparts. The first thing that she says is that an open door on a cattle hauler that they were following caused a hazard that caused her husband at the time, Greg Mascaro, another defendant in the case, to make a decision to pass that vehicle. She then goes on to say as the vehicle passed, as they started to pass the vehicle, the truck and toy hauler trailer they were pulling started to sway and waggle. After that swaying began, she claims the cattle hauler door that was open struck the trailer, contributing to the cause of the accident. And then finally she admits that she has no information that the cattle hauler, driver of the cattle hauler, did anything to cause the accident. So that's essentially her representation. Her representation doesn't involve a miss and run theory of causation, and for that reason we would suggest SECURA would be entitled to judgment.
Then why did the jury allocate 20% of fault to the cattle trailer?
Well, and I'm glad you raised that issue because I think that's an important consideration in this case. First of all, we would suggest to you that the only thing from the jury result that you should consider, and the only thing that the trial court should have considered in this case, was the answer to the interrogatory about contact. And the reason for that is this. In a corroboration setting, it's a coverage issue, and under Scruggs and really all and Blood, the other case, published case on the statute, corroboration is a coverage issue. It's not an issue for the fact finder. So you can't use the jury's verdict to be the corroboration or to confirm the corroboration. What's supposed to happen is you resolve whether there's contact or not, which happened in an interrogatory, and then the court is supposed to determine whether there's any additional confirming fact evidence that corroborates. So in Scruggs actually, in a quote, indicates that or recognizes that a claimant in an uninsured motorist case can actually prove their case to the fact finder. They can actually prove their prima facie case to the fact finder, yet not satisfy the corroboration requirement. So to the extent your question is, the jury found 20%, we would suggest to you that for purposes of this appeal, what the jury found with respect to the uninsured motorist is completely irrelevant, other than that there's no contact. You have to now go back and do it from scratch.
Let me ask, because I understand that, but doesn't one way to look at that interrogatory is that if you say it just addresses contact, you're kind of rounding off more than you should, because it talks about causation and contact. In other words, the interrogatory is not, does the juror, was there contact between these two vehicles? It is, was the accident caused, either in whole or in part, by any physical contact between the cattle truck and the vehicle here? So it's a little more nuanced than that. Now, I'm not trying to get in the mind of how the jury construed that, but it says, even a careful reading, I think, of the interrogatory could have had the jury finding contact that just didn't cause the accident.
Well, I don't think that was the conclusion that the court found. But let me respond.
And again, I'm not looking to look in the black box that is the jury deliberation, but it's not the high hard fastball interrogatory saying was there contact or not.
Well, let me address how I think that should be interpreted then, because the fact that the interrogatory asked for was there contact that was it did the contact cause, their conclusion was no, the contact didn't cause. So I think the only implication that you can really get from that is that then you have to determine whether non-contact, whether some negligent act that did not involve contact then caused the accident, which is really exactly what we're arguing here.
Well, and that's fair, but I'm not positive that's exactly the same of what you were arguing, but you've answered my question.
Well, let me see if I can answer that then, Your Honor. So to the extent that she has no miss and run contact representation, the next step that we would go to is to say, well, was there a representation upon that the jury might have answered that interrogatory? In other words, that the jury might have found, well, no, there are no facts, or we don't find the evidence sufficient that there was contact that caused the accident. What about some kind of non-contact event that caused the accident? And to the extent you want to use what the jury might have thought about that question, the answer to that question, again, is what we would say is irrelevant, because that's really for the court to decide, not for the jury. So if we go back and we analyze that issue, we have to look at what the representation is. So let's assume that you allow a representation of for miss and run purposes, even though the representation had only been for hit and run. Then the only representation you have in this case from Mrs. Mascaro is that an open door hazard caused her husband to make a decision to pass. And that's what she alleges. She doesn't allege any evidence or any theory of how the open door hazard actually caused the rollover. Did the open door hazard create some wind turbulence? Did it cause him to take some sort of, did it cause him to speed up? Did it cause him to do something? There isn't any evidence like that. So when you start to look at whether there's any other representation that could satisfy the corroboration provision, it would have to be based on this non-contact theory. And the evidence doesn't support it. Let me review what that evidence is. They point, first of all, to Jim Botsko, who was an expert hired by SECURA in the case. Mr. Botsko was really called to testify about the lack of contact, and he was also called to testify about the reconstruction of the accident. I think the evidence in the case really shows that the accident was caused because there was sway in the vehicle and Mr. Mascaro lost control. So what you have to have in order to find a causation representation is that some negligent conduct on the part of this cattle hauler driver is what caused the sway and the rollover, and that's what's missing in this case. Mr. Botsko didn't offer any kind of evidence to suggest that the open door itself was a causal factor. The decision to pass is not a causal factor. Causation, although we would concede that the jury instruction says causation only has to be, the negligence has to be a cause, not the cause, Arizona courts have always held that there's a but-for requirement, which is that which in the natural and continuous sequence, unbroken by any efficient intervening cause, produces an injury, and without which the injury would not have occurred. So to say that the open door which caused a decision to pass is a causal factor of a rollover is like saying, well, because I caught the light red an hour ago, it caused me to be late to work, and therefore the red light caused me to be fired. It doesn't make any sense. There's a lot of reasons somebody would make a decision to pass. A slow vehicle, a child in the car who has to use the restroom. There's a lot of factors that would cause somebody to make a decision to pass. And then, but to say that decision to pass is what is the causal connection to the rollover is just absent in this case. There isn't any evidence. The police officer doesn't add anything to that. Sherry Esquivel, one of the witnesses they point to, she didn't see the accident. She has nothing that she can offer other than what she might have overheard at the accident scene coming from the insured, which is the source of the original representation. Most importantly is the issue of her husband, Greg Mascaro, and whether he can corroborate. We would suggest that not only does Mr. Mascaro not corroborate, he actually contradicts her representation. In a minute, I want to argue that he shouldn't even be somebody you should consider for corroboration. But first, let me talk about his testimony. His testimony in the record is that as he was traveling north on Interstate 17 this day, he passed several vehicles. He passed vehicles that were going slower than him. He testified that he saw this cattle hauler way in the distance, and he saw the hay blowing out, thought it was snowing, part of the adventure, got the kids excited. And then as he approached, so it wasn't a sudden emergency that appeared to him. It was something that he saw from quite a distance. And as he approached the cattle hauler, he says he noticed that it was empty. So there's no hazard of any other thing falling out of it. He indicates that he normally would have passed that vehicle just like he would have passed any other vehicle that was traveling slowly. He approached it without fear or apprehension, and then just simply testified that when he started to pass, as what happens when you pulled trailers that weigh more than your truck, it started to sway and he lost control. And that's simply what happened. In fact, the police officer testified that when he first talked to Mr. Mascaro, he told him that he was passing a semi and lost control. It was that simple. There wasn't any conduct on the part of the vehicle he was passing that was alleged. So to the extent that the representation that we're trying to corroborate is that an open door hazard actually caused him to pass isn't really supported by Mr. Mascaro's testimony. But let me go a step further and talk about why Mr. Mascaro's testimony shouldn't be considered. In Scruggs, the court talked about what it meant to provide corroborating evidence. And when the statute was first promulgated, there was a question of, well, are we trying to corroborate the existence of this vehicle or are we trying to corroborate something else? And the Scruggs court recognized, look, we're not asking for independent evidence of the existence of this vehicle. We're asking for independent evidence of this vehicle causing the accident. And that's why you can have someone meet the corroboration requirement but not meet the prima facie case. And adversely, you could meet the prima facie case but not meet the corroboration requirement, is what Scruggs recognized. But more important than that, the Scruggs court looked to what it meant in the words in the statute are we want additional evidence and confirming evidence. Scruggs went so far as to look at Black's Law Dictionary for a definition of confirm. And what the Black's Law Dictionary indicated was that confirming meant confirm in Black's dictionary is defined as gives new assurance of truth or certainty. So in other words, the purpose of this statute is to give us something that makes us feel better about the veracity and credibility of the insured's testimony. And we would submit to you that a spouse, and remember they were married at the time that this representation was developed, that a spouse is not somebody who can give independent corroboration, but also has an interest in it. This court in Lindsay versus State Farm, the Court of Appeals, it was vacated on other grounds, but this court in Lindsay versus State Farm held that for purposes of insurance, a married couple constituted one insured. So when they were interpreting the statute provision that said when multiple policies are sold to one insured, you can prevent stacking of those policies, this Court of Appeals held that due to community property principles, a married couple was one insured. It makes perfect sense in this context because medical expenses that the spouse making claim incurs are presumed to be a community debt. Lost income that the insured may have sustained would be presumed to be a community asset. And for those reasons, a spouse is different than any other insured. If her vehicle was being driven by her brother, her sister, a neighbor, a coworker, or somebody else who would still qualify as an insured, that would be different because they don't have a conflict of interest. They don't have an interest in her claim. But when a spouse has an interest in the claim, we would suggest to you that they are one insured for purposes of carrying out the purpose of the statute.
That's a pretty big change of the common law. And wouldn't it be reasonable to expect that if that's what the legislature desired, that a spouse could not testify, that they would say it? And they really haven't.
Well, it's not that a spouse cannot testify. We're not arguing that a spouse should not testify.
But with that key point, you kind of are, aren't you? That the jury should not have heard that evidence.
No. What we're arguing, because on the jury doesn't get to consider corroboration. The jury considers the prima facie case.
Or the court should not hear that evidence. That witness for that purpose would be incompetent to testify.
Yeah, not that the court shouldn't hear it, but the court shouldn't consider it as corroborating. And for that reason, I don't think it is a change in the common law, because if you think about it, when interspousal immunity was abolished, as we cited in the briefs, the courts have indicated, look, we're going to let the court and we're going to let the parties and the attorneys sort of hash out any potential fraud and collusion sort of issues. But here the legislature saw fit to, after the abolition of this, saw fit to actually require that in uninsured and underinsured motorist claims, there be something more than just the regular offer of proof.
And I understand that, but your argument on this point, and I understand you've got another argument, is completely unrelated to fraud or collusion. It's per se.
But it's not really unrelated to fraud and collusion, because when you have an incentive, when you have an incentive because the injured insured is their medical bills are a debt that's also assigned to you, that you have an interest in it, and so the potential for fraud or collusion exists.
But fraud and collusion, potential, yes. Proof, no. You're arguing this should apply regardless of whether fraud or collusion is shown.
Well, that's I think the point of the corroboration statute is that when you're in a position where there's no identified motor vehicle, we have to have something that gives us assurances of truth and certainty.
Well, and my point is, if the intention by the statute was to completely, disable someone from providing factual information on that point, someone that is sort of predicted or predictable in the enactment of the statute, wouldn't the legislature have been more plain in doing that?
They could have, but as we see in statutes, legislatures don't always do that. And in this particular case, especially if you look at the entire statute, if the statute did intend to address at all the character of people who could provide corroborating evidence, then they would have. They could have also said, as they didn't in this, they could have said, any witness other than the insured making claim can provide corroboration, but they didn't say that. So that's part of the problem, is that the statute is somewhat ambiguous and susceptible to different interpretations, which permits you then to consider the purpose, the historical context, all of those other issues.
But I'm having a hard time with that argument, because the statute says, quote, corroboration means any additional and confirming testimony, fact, or evidence that strengthens and adds weight or credibility. Any additional. It seems like the gloss you're putting on the statute would not be consistent with the plain language of that. Now, whether it's believable is obviously a question of fact for the jury, so I don't think you can hang your hat on that adds weight or credibility. But any additional and confirming testimony, I don't see the limitation you're suggesting in this statutory language.
Our limitation is based on the word confirming. As the Scruggs Court interpreted, confirming means to give new assurance of truth and certainty. They use the word confirming. Scruggs interpreted confirming to mean something that gives us assurance of truth and certainty. We're saying that you can't have...
Decide. That.
Well, I think it's for the judge to decide, because the jury is not supposed to decide corroboration. The court is.
The jury decides credibility, but the court can't decide whether it believes the additional and confirming testimony before submitting it to the jury.
But they can conclude that it offers confirming, that it confirms. And that's what we're suggesting here, is that there should be a bright line rule that spouses can't confirm because of their inherent conflict of interest.
Despite use of the word any, and the fact that it is conditioned that this only applies, this additional corroboration requirement only applies to an insured making a bodily injury or death claim. Policies have lots of insureds, but it's the only one who makes the claim. So it seems that implicitly it would authorize, under the rubric of any, another insured who's not making a claim who could provide that additional in confirming testimony.
And we don't disagree with that. That's why we're not saying that you should preclude any insured. We're only indicating that you should preclude an insured who also is somebody who can't give assurances of truth and certainty. But the reason I argued this last is because it's not the most important argument. So I only have 1:30 left. I want to reserve
I
some
can give
time.
you a couple more minutes, so don't worry.
Okay, thank you. But what I want to bring back to, to close, though, with this is that the real issue here is not necessarily that issue, although we think that should be the law. But what we are arguing in this case is that Greg Mascaro doesn't offer any additional confirming testimony. The problem here is that there is no causation representation that an open door hazard caused a rollover. All it is a negligence representation. It's not a causation representation. There isn't any evidence that an open door somehow caused a rollover. The only representation is that an open door caused somebody to make a decision to pass, and the decision to pass is not enough. That's just simple negligence. It doesn't bring in causation. So essentially, that's our argument. I'll reserve my additional time. Thank you.
Morning again, Your Honors. The statute is very clear. It's any and an insured that is not making a claim. Greg Mascaro qualifies under the legislature statute. If the legislature had intended anything different, they could have certainly put it there. Certainly the legislature must have anticipated that the sheer number of accidents, what percentage involve husband and wife, and as Judge Norris pointed out, you can have multiple different insureds under different policies, and if they had intended to exclude, they certainly would have done so.
Let's assume we agree with that proposition. Can you address now Mr. DeChancio's argument that Mr. Mascaro did not offer the kind of corroboration required by the statute, which says corroboration that the unidentified motor vehicle caused the accident?
He did. He testified that he believed that the hay that was flying and that the door that was open created a hazard, and thus the reason for passing.
Well, that's the reason for passing, but he's suggesting that that's not the actual causation.
The jury determined that that was a cause and attributed 20% for that negligent, hazardous behavior as the cause of the accident. And they want to now take away from the jury's right and entitlement to assess causation based upon negligent and hazardous behavior and ask this court to take that away. And the jury heard the evidence and determined, based upon the evidence, that that truck comparatively responsibly caused part of this collision. The representation that they're trying to splice out, that Trish didn't make a representation of a non-contact, doesn't go anywhere, because if you think of the circumstances of this accident, this was a 70-mile-an-hour rollover. Trish is hanging upside down with the compartment completely crushed in, and she's doing her best at the scene to communicate with an officer and an independent witness as to what's taken place. Her belief is that there was a contact, but to require her to be exactly precise as to exactly how this collision took place is clearly contrary to what the law would expect. At the scene of the collision, before a witness arrives within a couple of minutes, there's already confirmation coming from Greg Mascaro, from the kids, and from Trish of this truck, of this hazard, of this open door, of this hay flying. That's corroboration as anticipated by the statute, Your Honors. And I believe that, again, the jury has made a decision that that was the cause, at least in part, of the collision, and that was, again, substantiated and corroborated by Greg Mascaro, as well as substantiated and corroborated by Mr. Botsko and the independent witness as well, or excuse me, and the officer as well. I see that Mr. Giuccio has not addressed other two items in his oral argument. I'm assuming he's reserving that for later, and I'll address those now. As it relates to the value of the case, You have evidence that was presented establishing over $300,000 in medical expenses, future care costs likely anticipated over $1 million. My client, Trish Mascaro, underwent multiple surgeries, spinal surgeries, shoulder surgery, scar revision surgery. She's left with residual scarring. She's left with residual restrictions. She's left with limitations. She's got significant future care costs. And for a jury to award her essentially $700,000 for a lifelong of injuries on top of her future and anticipated and well-presented future care costs is anything that shocks the conscience of the community. And as a result, I'm assuming that he didn't address that in open court because he realizes there's really no merit to that argument. As it relates to the misconduct, Judge Brain went out of his way to tell this court and anybody else, hey, listen, Mr. Moulton, your argument and your personal dissatisfaction with the jury, I'm sorry that's the case, but what you allege in terms of misconduct and how this case was tried was clearly not the same case that Judge Brain heard. And Judge Brain's minute entry went very clear and well stated that this case was presented in accordance with the rules. There was a contention that there was collusion that took place between myself and Dave Panzarella. There were avowals to the court. There has been no evidence, not a shred of evidence substantiating anything to the contrary because none exists. So we believe that that argument bears no merit as well. We've laid out very clearly our position on each of the arguments. Really, the only one that the court need to decide, which Mr. DiCiancio spent 90 or almost all of his time on, is the corroboration argument, which again I believe has been well stated by our position in our paper, along with legislative intent. Had it been contrary, they certainly would have so stated.
Counsel, let me ask you, recognizing its opening statement, not opening argument, there's some pretty aggressive PowerPoint slides there. From the record, I'm not quite sure what the jury saw.
Sure.
But had they seen everything, there's some things in there they probably shouldn't have.
There's some that they didn't see, and I did my best to follow the court's direction and order in that regard. And some of the slides that I prepared in advance were thoughts. They were not published to the jury, and the defense can't, or the appellant can't present evidence to the contrary. Really, the only slide that we know that that they really take issue with is Dr. Merrick, and Judge Brain went into great detail as it relates to fair game on cross-examination with Dr. Merrick. This is a situation where I got caught up in arguing defendant or defense, and the defendant and defense are not the same in this particular case. They're aligned in certain arguments and not aligned in others. So in order to distinguish who I was talking about at any particular time, I referred to defendant Greg Mascaro or defendant SECURA and or Hartford Insurance. They're a named party in the action. I don't know how else I can argue, hey, SECURA Insurance is taking this position versus defendant Greg Mascaro taking this position. It's the plain and simple reality that we have defendant insurance companies involved in this case, and that's how they were referenced. There were things that defendant SECURA Insurance was arguing that defendant Greg Mascaro's counsel was not, and vice versa. As it relates to what was presented was only in accordance with what the Judge Brain had allowed me to present. That's all I have, unless you have any other questions, Your Honors. Okay, thank you.
Thank you, Your Honors. I'll be brief. The on the corroboration issue, the problem is and we anticipated that they would argue this because they did in their response brief, was that because the jury awarded damages, therefore corroboration existed. I think it's a mistake to conclude that, because corroboration under Scruggs clearly is an issue for the court, not an issue for the jury. The jury was asked to decide one interrogatory issue. We don't take issue with the procedure because I don't know any other way to do it. But the court should have gone back, and what the court said in his ruling was, we find that a reasonable jury could find that he made the open door made the decision to pass, and therefore he denied the motion for new trial and the motion for judgment notwithstanding the verdict on that basis. That was the judge's error too. He did the same thing that they argued. Corroboration is not supposed to go to the jury. It's an issue for the court. The second thing I'll say very...
Let me ask you, and I know you're in rebuttal, and I'm mindful of what Presiding Judge Norris has directed, so I apologize to interrupting, but what you're saying that can't be a proxy, that the court finding that the looking at what the jury did therefore suggests that there was a reasonable basis to find corroboration, that's wrong. Is that, am I hearing you right?
Yes, that the jury, because normally what would happen in a case where there was no allegation of a hit and run causation representation, these issues would all be decided pre-trial, and it would be the contact is usually undisputed. In this case, it was disputed. If it were undisputed, the court would have to make this decision without the benefit of a jury.
Well, and the analogy I have that I want to run by you is, isn't that like, and it's an analogy, okay? If there is a Daubert motion pretrial and a request for a hearing, and the hearing is denied, okay, but the evidence is allowed, on appeal we have far more to look at. We have the context, we have the testimony, we have, what happened at trial, far more information to determine whether that was an appropriate call or not. Now, we always look in the rearview mirror. We don't, sort of project forward. But isn't the process that happened here akin to that? Because the court had all of this, sat through every minute of trial to look at and to think and to then make that call.
If I were arguing that issue on appeal, I would respectfully argue, Your Honor, that no, what you should have considered is what Daubert tells you should consider, which is all of the signposts and the criteria that goes into deciding whether something's admissible, not what the jury decided. The jury doesn't decide admissibility. So I would even say a post-trial Daubert ruling would still be something that has to be divorced from a jury result.
Well, but I don't hear, and maybe I'm not reading it through the right lens, but I don't see what Judge Brain did here as saying, well, the jury found for plaintiff, there's nothing for me to see.
Let me tell you what I think Judge Brain did, which is my final point, actually, which is what Judge Brain should have done is he should have said, okay, the representation is that an open door created a hazard because hay came out, okay? And what he should have said is, where is the representation that hay coming out of the back and a door being opened caused a rollover accident? And B, where is the corroboration of that? Because it didn't come from any of the witnesses that testified. In Scruggs, what happened is the insured had a representation, a miss and run causation representation. She hired an expert who came in and said, yes, there is physical evidence that independent of her, physical evidence that supports, adds weight and credibility to her version of the accident. She didn't hire that kind of an expert in this case. She could have had an expert, if an expert would have come into this case and testified that because of the open door, it created a wind turbulence that caused sway, or because hay was flying out, the weight of the hay knocked the trailer and caused it to sway, or there was some kind of causation evidence, then I could see that. But that didn't happen here. So unlike Scruggs, she didn't do that. So what I think the judge should have done is said, is there a representation of hay coming out at an open door? Did that cause a rollover accident? And if he found the answer to that was yes, then his next question should have been, what evidence corroborates that? And neither of those exist.
Let me ask a somewhat related question, and I'm just not exactly sure I understand how this is unfolding. If I perceive your argument in part to be that Patricia, and I use her first name because everyone has the same last name, did not prove that this was a hit and run, that she failed to provide an adequate proof of that representation that the accident was caused by a hit and run.
I wouldn't say adequate proof. I would say initially she never made a representation that this was anything other than a hit and run.
There is a failure in making that representation. That is arguably an evidentiary failure. In your new trial motion, however, I'm not sure I saw an argument that she had failed to either present evidence to prove her representation that this was a hit and run. And if it's not in your new trial motion, haven't you waived the argument under 12-2102?
No, it was I think it was part of the motion for judgment notwithstanding the verdict.
So that's where I would look for it.
Yes.
Okay. Okay.
Right. Thank you, Your
I
Honors.
interrupted you. Would you like? All right.
No,
Did you have anything else
you
you
know,
wanted
just
to
on
add?
the one issue that we didn't address, I think the briefs speak for themselves. There was an order in limine. There were arguments about SECURA's investigation. It's tough doing business in Superior Court as an insurance company, as I'm sure you can appreciate. And so, anything that suggests bad conduct on the part of the insurance company is an uphill battle, and I think the rest of it's in the briefs. Thank you, Your Honors.
Well, thank you both for your briefing on appeal and your argument today. We'll take this matter under advisement and issue a decision in due course. Thank you very much.